Hi, this is Jonathan Armstrong from Punter, Southall Law. Hope it's not too late to say Happy New Year. And we're back with our traditional Tech Law 10 predictions for the year ahead in tech law. I'm imagining it's 15, 20 years we've done this. Eric, I think we've got more right than wrong. With me is Eric Sinrod from Dwayne Morris over on the west coast of the US. And for those of you who haven't watched or listened before, we normally try five predictions each. We normally overlap. Uh, Eric, what's your first?
I'm excited to see what you have in store. Yes, I'm Eric Simrod at Dwayne Morris. Happy New Year. So, where do we begin? Big surprise, AI regulation, and state patchwork. So, the push for federal AI legislation here in the US, it's expected actually to face some gridlock in 2026. So, instead, potentially regulation will be driven by state laws and state attorney general enforcement using existing statutes. Key developments, we should expect laws focused on areas considered less controversial, at least at first, like child safety. We see California's new regulations on automated decision-making technology, ADMT, which took effect at the beginning of this year. It requires opt-outs and human oversight, setting a likely model for other states. Impact on business. Uh, we have a growing compliance challenge for companies operating nationwide, requiring them to navigate differing rules on transparency, bias audits, and human review. So I mashed up quite a bit briefly because we have a number of points into number one.
Yeah, I think I've also got that on my bingo card as well, I guess. Um, I think regulators are becoming increasingly active. Obviously, we've got the EU AI Act and the provisions of that are being phased in. If you are relying on the EU Digital Omnibus to save you and to make sure that the EU AI Act doesn't apply to you, I think you're better off betting on the Kentucky Derby. I don't think that is going to save people. So my bold prediction is that the EU Digital Omnibus won't pass in 2026, which will mean that further provisions of the EU AI Act are likely to be binding on people. So you've got to take time to look at that. Obviously, we're seeing local implementation now of that legislation in Hungary and in Italy. I was in the US last week. I agree, obviously, with you about the sort of fragmentation of legislation, both in the US and in Europe. I spoke at a program at Fordham University. We had some interesting discussions on what that means. But obviously, as we've said it many, many times before, don't disregard existing enforcement. There are old school regulators like antitrust regulators, competition law regulators, data privacy regulators who already have an ambition to regulate this space. We're probably around the 300 million euros level of fines across the EU. That will grow, and regulators will also respond to concerns from the public they represent, whether that be grok nudification, whether that be chat lines directed at children, etc., etc. Existing legislation will be retooled, if you like, to regulate AI as well.
Well said. Shall we go on to number two?
Yes, we
And
shall. Yeah.
my five aren't necessarily in order. They're just the five I'm putting
No.
up here. So second, in terms of presentation, is our patent office push versus court reality. Again, this touches on AI. It's possible we'll see a significant divide persisting between our U.S. Patent and Trademark Office, our PTO, and its approach to AI patents and how courts rule on them. At the PTO, the office is actively working to make it easier to secure patents for AI inventions. New guidance instructs examiners to focus on whether an invention represents a technical improvement and gives thus applicants more tools to argue for eligibility. However, in the courts, the federal circuit here and district courts remain skeptical, often invalidating patents they deem to cover abstract ideas without a true inventive concept. So this creates uncertainty for patent holders as a patent granted by the PTO may not survive in court.
Yeah, well, good news for IP lawyers then.
That's
And
true.
mine's also, I guess, good news for IP lawyers in some respects. I am increasingly interested in something that I'm calling AI vacuums. So, what's that about? Basically, uh, we've had scams as old as the internet, really, where people have done things like typo squatting where instead of blooming Dale, they've had blooming Dales or vice versa and
Right.
diverted traffic away. We're seeing that, I think, in AI enabled search. So, as you will know, most major search engines have an element of AI, and you can usually toggle it on or toggle it off. But people will be using Gemini assisted search, for example, in place of their usual Google search. And why does that create issues? Well, it's because some corporations seem to be AI invisible. And I've written an article on this and we'll link into it in the notes at the bottom of the page so that you can get more details. But effectively, a lot of organizations have tried to protect their intellectual property on their websites by instructing crawlers not to crawl over their site. And that means that they're no longer the primary source of information about their corporation, so somebody else could be. It's relatively easy for threat actors to sort of influence those search engine results to um, to support phishing attacks, to divert customers, like we've had in typo squatting in the past. So if you're a CISO, if you're the chief compliance officer, if you're responsible for compliance and security in your organization, then maybe it's time to reach out to the brand protection team if your organization is large enough to have them. They're using tools like domain name infringement that might be wise to circle up with them, might be wise to look, just as you look at search engine optimization, to optimize search engine results, to look at optimization, maybe to remove those instructions for robots not to crawl, look at other techniques to make sure that your brand is yours in AI enabled search rather than somebody else being able to take advantage of it.
Very good. Wow. Harkening back to the ancient internet days of typo squatting, I
Yeah,
recall I recall those cases like Microspot instead of Microsoft. But okay, we carry on. Number three, here in the US, does data privacy enforcement get real in 2026? Well, in 2026, it may be the year of enforcement when we look at evolving state privacy laws and whether, we're now moving from theory into practice. So, three new state comprehensive privacy laws in Indiana, Kentucky, and Rhode Island came into effect on January 1st this month. Amendments in states like California and in Oregon are significantly expanding obligations. So, regulators could be focusing on in 2026 universal opt out mechanisms, data protection assessments, and data broker compliance. So that's my number three, keeping it simple and short.
yeah, very good. My number three then is tech becomes more political. And by which I mean that tech seems to be the new arena for some political disputes to pay out, particularly state versus state. So we've had quite a lot of examples of this recently. TikTok and the separation of TikTok activities in the US, the moves against DeepSeek, and we've talked before about the actions that the Garanta took around this time last year to launch the start of an investigation to suspension in about 3 days, which is unheard of in terms of timelines. We've talked about replica AI. I've already talked about the political ill will around Grok nudification, and that's perhaps influenced by the fact that the majority owner of Grok, I believe he is the majority owner, has himself being a player on the political scene, and is somebody for whom an opinion is easily shared. So I think it's a worry for organizations, as even if they're not using those services, they might be relying on them. There's a bit of obfuscation around some services like AI, where you know that the AI application you are using is relying downstream on someone else's technology. Is it DeepSeek? Is it Grok? Does that cause you issues if they're suspended? We know that even OpenAI have had applications suspended in Europe. So that's a potential worry for organizations. And one of the things, and in addition, sanctions has a role here. We've already seen that with North Korean threat actors being sanctioned. We've seen that with high tariffs on chips and hardware, increasing cost for tech as well. So I think one of the practical things is people will try and diversify their supply chains. They might try and buy different types of kit from different locations. And for example, we've been experimenting with an AI application where it works out the task and then bids the task against different LLMs to see who's going to deliver more quickly, who's going to deliver at lower cost. And we might find more of those arbitrage type applications in our businesses where we're not looking at just one LLM or one tech provider and trying to balance the risk out.
Thank you. Well, you mentioned political, and this didn't come within my five, but I think about our congressional elections that are very important for the end of 2026 and how technology will play a role there. But that's not within my five. Should have been, but thank you. You mentioned lawyers. Well, my number four has to do with lawyers and legal industry AI adoption. So perhaps in 2026, we're going to see strategic integrated AI deployment becoming a major competitive differentiator for law firms. So will we see a gap emerge between firms that show client value using AI appropriately and those relying on hype just to boost up premium billing? I know there are a lot of concerns about how lawyers should or should not use AI, but will this be a feature in 2026?
Yeah, that's a fantastic topic and one that's worth a podcast in its own right. And obviously, a lot of the work I've been doing at Fordham has been around. We've been looking at alternate models, how do firms price, et cetera, et cetera. I maybe give a quick plug. As you know, Eric, I was on the New York State Bar AI Task Force. We delivered a big report on this in, I want to say, May 24. There's a new report out this week again, from the New York State Bar on artificial intelligence and access to justice, brand new off the stocks, although some of the survey results are somewhat older when the surveys were done. But there's not much adoption of AI, it seems, statistically in legal services. Lots of people talking about it, but I think its use is exaggerated. Over 88% have said they don't use AI. I don't think that bit is accurate, in that I think it's 88% don't know that they do use AI. And I think that maybe links into the topic I was going to mention next, which is the whole business of shadow AI. That a lot of the cases we're seeing, things like hallucination cases, are people not knowing they've been using AI. They've been saying, oh, I just did a search engine and it came up with these results. And there's a lot of accidental use of AI and a lot of use of shadow AI to get jobs done. And I think there's all sorts of statistics about that being, some jurisdictional differences, people being more task orientated. I think 50% of driving tests in the UK have had a cheat element, with a generation coming online that is using, is blurring the line between hacks and making things easy and not following the rules. So I think there's all sorts of issues there. Obviously, things like literacy will be key, training will be key. Remember, it's mandatory already under the EU AI Act if you touch the EU with your data. Obviously, some of the cases are fun. I personally am a favorite at the moment. I don't know whether you saw the Netherlands wedding case where two cool kids used ChatGPT to draw up their wedding vows. ChatGPT apparently does it wrongly. There are mandatory wording in the Netherlands for a marriage to be valid. And they say they've suffered, pretty significant harm. Their tax structure was built upon them being married. There's apparently different treatment, married couples versus non-married couples in the Netherlands for a tax point of view. So cases like that are maybe slightly amusing, and some people might say it serves them right. But I think there are obviously clearer implications. We talked with our special guest last time about the implications in medicine, implications in law. We're north of 800 hallucination cases. We've got allegations that judges are hallucinating in judgments. We got a debacle here in the UK last week where a police chief refused access after it is alleged a push by Muslim organizations. He refused access to traveling Israeli soccer fans. His force prepared a risk report to justify the ban on Israeli fans. And they referred to a soccer game where there'd been violence. And that soccer game just didn't exist. And eventually, after a long drawn out process, a couple of parliamentary inquiries, the police chief has admitted that the force used AI and it had hallucinated this non-existent match, and traveling fans from Israel had been banned as a result. So we're seeing consequences of hallucination. We're seeing consequences of shadow AI and accidental use of AI. And regrettably, that problem's going to continue. The answer is good literacy programs.
Two responses before I get to my fifth and final. When you mentioned the Netherlands wedding case, it makes me think about the ancient common law doctrine of assumption of the risk. At some point, are people assuming the risk when they use AI that it might not be accurate in many contexts? Often we're seeing that to be the case. And isn't it interesting how much now we're talking about AI as we've done year-end roundups, we've done year-in-advance predictions. We've been doing this, as you said, about a decade and a half. For a long time, we never talked about AI. Why?
Yeah.
Because it wasn't so predominant. And now it is forefront. I will get to my number five. It has to do with cybersecurity. That's a theme we've touched on frequently before. But I think it's possible we're going to be seeing enforcement actions here in the US, which are seeking to shape reasonable security standards. Courts will be scrutinizing incident responses, and organizations very well could be facing pressure on cyber governance and tighter rules relating to breach investigations. Do you agree with that?
That was my number five as well. I think echoes exactly what you said. The other thing I'm seeing is more and more vendor compromise. So organizations are working out that, I can compromise one payroll provider and I've got the chance of 1,000 corporations paying me a ransom because I'm holding their payroll data through they've outsourced it to a third party. So a lot of these people who provide services to corporations, I think, are becoming the real target of attacks just because of this multiplier effect. We've dealt with a lot of those in 2025. I've already chalked one up in 2026 with I've already made a report to a regulator on that sort of fact pattern. And I think this is going to be a growing trend. And I think the other thing I'm watching with interest is what I'm going to call PTAs, poor threat actors. So I think a lot of organizations are unable to distinguish when they get a ransomware attack, whether it's from what you might call one of the daddy groups that are often state sponsored or state condoned, or whether it's a sort of your regular cyber criminals who are just shilling for money. I've had cases where they've used really old exploits, and a cure tool has been available for free to get rid of this ransomware. But because of the menaces from the gang, people have paid. So I think we're going to see a clearer division between, if you like, Premier League threat actors and the Vauxhall Conference, sorry to use an obscure soccer reference, the Division 3 threat actors who were using menace rather than guile and knowledge. And I think that's worrying because obviously we're going to get more of them. It's easier to stack up. You can buy all the kits online. You can even buy data online to threaten people. So I think the cybersecurity world, again, looks challenging. And as you rightly say, regulatory activity, I think, is likely to increase not only against data controllers, but also against data processors. So against tech companies themselves, for all of the reasons that we just briefly explained. So I think, as lawyers say, consensus ad idem, Eric.
Thank you so much. Ray sips a loquitur to you too. Um, well, time will tell. We will be with you. Thank you for joining us, and we will see as the year progresses and toward the end of the year whether some of these predictions or all of them have come true. And of
Yeah,
course, we're reporting on other developments because we're just slicing off just a bit of the pie here. So thank you, Jonathan, for joining me as always. Thank you for Adam for putting this on for us. He does a great job. And my name's Eric Sinrod at Dwayne Morris in the San Francisco office, ejsinrod at dwaynemorris.com. We're looking forward to being with you frequently in 2026. Jonathan?
yeah. Thanks very much, Eric, and great to be doing this with you for so long. And thank you for jumping out of your sick bed to join us. I'm Jonathan Armstrong, jonathan.armstrong at Punter Southall.law. If you agree, disagree with our predictions, we've got a LinkedIn group. You're always welcome to pitch in there and tell us. And we look forward to seeing you next time around. Thanks for watching. Thanks for listening. Bye for now.
Bye. And I'm feeling renewed vigor being with you.